Welcome, everyone. On behalf of Scott and myself, we'd like to welcome you to the May 2023 Compliance Corner video. And as we have done over this last fiscal year of the Wisconsin Bankers Association, we brought to you each month a series of new releases by the agencies just to make sure that you are aware of what's been issued and what potentially to expect in an upcoming compliance examination. And this month is no different than those past months. Well, you will see in our next slide an agenda of the items that Scott and I are going to cover today very briefly, again, to make sure that you're aware of what the agencies have been up to. And so today, first up, we're going to be talking about some fees that Freddie and Fannie were to have been issuing, but I will reserve the news for Scott to deliver. We're also going to be talking about FDIC deposit insurance webinars. We know that many of you have questions as bankers. We've been getting those calls, so heads up, there's going to be some upcoming webinars. We have some updates on our favorite rule of the spring here, that being Section 1071. There are 4 different guidances that were issued here recently, one by FDIC, one by the Bureau, one by OCC, and an interagency statement that we'll be mentioning. And then there's actually been a court case here, not local, but is something certainly that we all should be mindful of, especially those that are in the credit card business, which some of our bankers here in Wisconsin are. So with that very brief intro, Scott, I'm going to turn it over to you, and let's talk about the exciting news, I guess, exciting, by FHFA.
Sure. Thanks, Heather. I think this is some of the more exciting news we've gotten recently, as this is an issue we've been following the legacy of for some time now. And so we have an update for you on the FHFA fee pricing framework. And recently, FHFA announced that it rescinded the upfront fees based on a borrower's DTI ratios for loans that are acquired by Fannie Mae and Freddie Mac. And so the kind of legacy of this has been, as we've been talking about through these videos over the past few months here, FHFA has been taking steps since early 2022 to update the enterprises, so Fannie and Freddie, single family guarantee fee pricing framework with a special focus on these upfront fees. And then in January of just this year of 2023, which we had discussed, FHFA announced a redesigned and recalibrated grid for the upfront fees, in addition to a brand new upfront fee for certain borrowers. And this was based on a debt to income ratio above 40%. And so the mortgage industry had provided feedback on this, had written to FHFA, and had been engaged with FHFA due to that feedback from the industry regarding operational challenges which would result from the implementation of this specific upfront fee, being the DTI ratio-based fee. FHFA did decide to rescind that fee. And so we have that in the first bullet point for you there. And then FHFA in that announcement did indicate that it intended to issue a request for information on the enterprise single family pricing framework as a whole, which has since been released. And so we have that in addition to the rescinding of that. FHFA is still considering this new framework and the methods for which they approach these frameworks, but is now opening up to comment and going through a more formal process here on its goals and policy priorities, laying that all out and looking for input on that, as well as the process for setting the enterprise's single family upfront guarantee fees, including whether it's appropriate to continue to link those upfront guarantee fees to the enterprise regulatory capital framework. So that's the update on that. The good news, of course, being the rescission of that fee that was going to result in industry burdens, and that FHFA has initiated a comment process on this entire framework as a whole. So those comments are due on August 14th. We've got the links for you in the description below if you'd like to know more about the rescission or the comment process. With that, I'll turn it over to Heather for our next topic.
Super. Thanks, Scott. And I'll just add that we'll be filing a comment letter on behalf of the request for information that Scott just mentioned. So if you happen to have particular recommendations or comments you want us to include, feel free to reach out to us. We're happy to have the conversation. So the second topic we wanted to make sure that you were aware of is that FDIC will be hosting a series of webinars on the topic of deposit insurance. These are free webinars. There are 5 different webinars. They will be approximately 90 minutes in length, and there's a moment of time they take for questions and answers. The series of webinars are held from May through October, and there'll be 3 sessions, which will be on the current rules as they are today. And then they'll have 2 sessions on the rules that are going to be changing in 2024 as it relates to revocable and irrevocable trusts, just so that bankers can become more familiar with those rules as we go forward. We've written on that upcoming rule in the past WBA Compliance Journal, which you can find on our website, but certainly register for these webinars. They are helpful webinars and are a good training tool for frontline staff who may be fielding questions about FDIC insurance. It's worth the 90 minutes for those that deal with those types of questions. So we have the link for you included in the link materials below so that you can register directly with FDIC. So Scott, I'm going to throw it back to you.
Yeah, sure thing. So we've got some updates for 1071. And in our last video, we talked about a lot of the resources that CFPB had put out along with the 1071 final rule. And the update we have here is a new CFPB compliance guide, as well as an update regarding a lawsuit. So the small entity compliance guide follows the same format of what you're used to with CFPB's small entity guides. And so there's quite a bit in there. It's a good way to kind of condense the rule if you're looking to find something quick and have a supplement to the rule itself. And the bullets on the slide, you can see everything that it's in there. So it's rather comprehensive in what it has, gathers some summaries, presents it in a little bit different light. Again, more as a supplement to the final rule. We also wanted to mention this lawsuit. And so the Texas Bankers Association has filed a lawsuit to block implementation of CFPB's rule. And so within this lawsuit, the argument is that the rule goes beyond the requirements of Section 1071 of the Dodd-Frank Act, which is, of course, the law that CFPB is writing the rule to implement. More specifically, calling out the 13 data points that are specified in the Act and how CFPB goes well beyond that. But there's more to it, and the plaintiffs include the burdens that are associated with new software, compliance mechanisms to meet this data collection, which would, in essence, stress small business lending and ultimately harm the businesses it's designed to accommodate. But what the argument really relies on heavily is the Fifth Circuit Court's ruling finding CFPB's funding structure unconstitutional. And so in super short summary, therefore, the argument is that this rule, the 1071 rule issued by CFPB, is invalid, and financial institutions shouldn't have to expend this significant of resources to comply with an invalid rule. We'll, of course, wait to see the result and what comes out of this ongoing case. But in the meantime, it's very important to stay on top of implementation considerations and look at what's coming up, look at the rollout, consider what needs to be done, and using the resources that CFPB has, obviously consulting with the final rule itself, but also consulting with that entity compliance guide and making sure that your financial institution is ready. All right, I'll turn it over to slide 6 for Heather to cover some recently released agency guidance.
Thanks, Scott. So there's a lot on this page, but I guess the takeaway will be that there are 4 items that we're going to be talking about here very briefly. 3 of them are concerns over UDAP practices, and the final one is about completing LIBOR transition by the June 30th deadline. So the first one in the top left-hand corner of your screen, you will find that FDIC has recently issued guidance regarding UDAP and the worry of charging overdrafts on what's referred to as APSN transactions, that being that the transaction was authorized when the deposit balance was positive, but then was settled when the balance was negative. And this type of transaction was first identified in 2019 as being the type of transaction that the regulators were concerned about. And if in fact you have a transaction where the transaction was authorized when the balance was positive, it was paid and settled when the account was negative, and you charge an overdraft fee, you can anticipate regulators taking scrutiny over that type of a charge and likely looking to cite UDAP on that scenario, that the charge should be settled but not have an overdraft fee associated with it. So certainly work with your vendors. I know that many of you have already done that and have already watched the transactions to make sure that there were not overdraft charges occurring in this type of a setting. So it's a nice reminder to work with the vendors and make sure that you are tracking that and not imposing an overdraft charge when that balance is negative upon settlement. Also, a UDAP concern is CFPB's take on unilaterally opening deposit accounts that had previously been closed by customer. So the scenario being that the customer came in and requested the account to be closed, maybe they were moving, for example, and did all the steps necessary to close out that account. And lo and behold, there comes forth a transaction that needs to settle against the account. And that transaction then, by needing to settle, reopens up that deposit account. That deposit account then sits there with potentially a negative balance and racks up some fees, and the customer doesn't know. I think we've all can identify those types of transactions. Well, what the CFPB is warning against is that unilateral reopening of that deposit account without the consent of the customer can be a UDAP situation. Again, work with your vendors. It's our understanding that it is a particular code that needs to be set so that these transactions, when attempting to be posted, are returned and are not posted to the account. And the account's closed and it's not reopened. So something to carefully take a look at to make sure that you're not imposing overdraft charges or other fees when those accounts are being reopened, because that's considered to be unfair and deceptive. The OCC issued a risk management type of guidance where they've incorporated a number of these concerns collectively into one guidance. Or they're talking about the authorized positive, settle negative situations, the representment of fees. But they also talk about high limits or lack of daily limits on a number of fees that can be assessed on an account as being a UDAP concern, and sustained overdraft fees. So fees that are being out there for a long period of time, those are also UDAP. So take a look at the OCC regulation if they are your primary regulator, because they're incorporating the other agencies' concerns into their own risk management practices and principles. Separate from UDAP, as I mentioned, is the LIBOR transition. So there was an interagency statement issued reminding all of us that we need to make sure that we have transitioned away from using US dollar LIBOR rate in our contracts, as those panels are set to terminate in June of 2023. We've written on all of these topics in the most recent compliance journal, so I'm going to refer you to there to read the more detailed nitty-gritty about it. But we certainly wanted to make sure that you were aware of these and you have links to each of these items. So back to you, Scott.
Thanks, Heather. So just one more thing to cover before we wrap up here. And this last topic is, recently a settlement was reached between CFPB and Citizens Bank, which, as Heather had mentioned, is a larger institution on the East Coast, to resolve a lawsuit from 2020 alleging that Citizens Bank had violated truth in lending and Reg Z through a few things that are laid out on this slide here. But to kind of break it down for you, it was that the bank was improperly denying customer reports of fraud and errors. And this was through methods of not responding to errors by throwing up roadblocks and hoops for customers to jump through, as CFPB gives examples of what those are, such as requiring affidavits of fraud and failing to provide refunds. In short, by failing to reasonably investigate error notices from their consumers. And then also failing to provide required documents and referrals by not responding to reports of billing errors. So it really is that error resolution process at issue here. And so then the stipulated judgment, if entered into by the court, would require fixes to those practices. So involving the handling and resolution of those billing error notices, such as specifically prohibiting employees from putting up those stops, such as specifically prohibiting employees from requiring customers, for example, to provide an affidavit of fraud before even initiating those claims and that dispute process. And then bank must also ensure that it refunds any fees or other amounts within the dates of error and pay a $9 million fine. So we just wanted to include this, despite the fact that this is not necessarily within our territory, to be aware of this and be aware of what CFPB is looking at for your credit card services. Should be mindful of this and make sure you're aware of what your error resolution process is, what your dispute process is. Are you responding to it appropriately and consistently with your customers, and making sure that those rights are afforded to those customers. Right. And as always, we want to wrap up here and remind you of all of the resources that are available on the WBA website. So we, of course, have monthly updates to our website. We've got compliance tools and resources, publications, training, in addition to the compliance hotline. The most recent compliance journal is on there, as Heather had mentioned. So if you're looking for more information on those recent agency guidance, there's great information. The compliance journal can be pulled right up on there, downloaded or printed off, however you prefer to view it, as well as past editions. And in terms of most recent resources, we also just added within the past month here, a resource that is a deposit banker's guide to LLCs. And so we know that many of you and your staff deal with LLCs, and they come in a variety of shapes and sizes. And there's a lot of unique situations on the deposit side of how to deal with those business customers that are running limited liability companies. And so we wanted to create more of a comprehensive guide, providing some fundamentals on dealing with them, as well as a Q&A addressing some of the more common scenarios that you see and how to resolve it. So if that's something that you can use, would recommend referring to that to see what's in there. Working with your staff on that as well, maybe to help for training opportunities or work with those who might not be as familiar with LLCs. So as always, thanks for joining us. And if you have any questions, don't hesitate to reach out to us either through phone or email. And we look forward to talking to you next time. Thanks, everyone.